Welcome to the webinar presented by NatRoad HR Advisor Kylie James. Kylie will explain a few key issues members need to be across in the HR space. If you're a NatRoad member and need personalized support, please contact us on membership@natroad.com.au. Over to you, Kylie.
Thank you, Michelle, and hello to all our members and also those who are not members listening today. Today, I wanted to cover off some HR essentials for you to think about in your business throughout 2025. So what are we going to cover today? We're going to cover the wage theft laws. We're going to talk about updating your employment-related documents, termination of employment, casual employment, psychosocial safety, and also I thought I'd cover just some common award questions from members that have come through over the last couple of months. What I did want to note was that not every workplace and every employment arrangement is the same. It is very different. So this is general information and it's not intended to be legal advice. The presentation references materials and information from the Fair Work Ombudsman, Safe Work Australia, and mainly the transport awards that are used throughout the industry. We recommend that you contact us directly to discuss your specific situation. We also have some fact sheets available on our website that give you some further information on a variety of topics to help you manage your employees. So we'll dig into the detail now. So first of all, the new wage theft laws, they commenced on the 1st of January 2025. So what these laws are about is to ensure the intentional underpayments of wages or entitlements are not happening. So there's actually criminal offences that can occur now if you are found to intentionally underpay employees in your business. This doesn't come into effect if it's an honest mistake. And so the FO have given us, a little bit of guidance around, I guess, what it means if, what it means for an intentional underpayment of wages. So they've indicated that an employer may commit a criminal offence, i.e. they've intentionally underpaid wages or entitlements, where they were required to pay an amount to an employee such as wages or paid leave entitlements on behalf of the employee or for their benefit such as superannuation or a salary sacrifice arrangement. And they have intentionally done something that intentionally results in those amounts not being paid or on before the day that they were due. So there's also been a voluntary small business wage compliance code that has been established. And we are going to put a link to this on our website as well, so you can access that code. A small business employer cannot be referred for criminal prosecution by the Fair Work Ombudsman if they have underpaid an employee and the Fair Work Ombudsman is satisfied that they have complied with the Small Business Wage Compliance Code. So in relation to a small business employer, that is an employer with fewer than 15 employees at a particular time. So this is essentially what the the Small Business Wage Compliance Code declaration looks like, and we will include a link to this on our website. So how do you comply with this code if you're a small business employer? A small business employer will comply with the code if the underpayment was not intentional. So as I mentioned before, intentional conduct includes taking an action such as paying less than an employee's minimum entitlements on purpose or failing to take an action such as not paying an employee on purpose. The code is not a checklist, so it's not a tick and flick exercise. Where an underpayment has occurred, the Fair Work Ombudsman will look at the overall picture and what the business's particular circumstances are, and then they will make a decision whether the code has been met satisfactorily. The FO has given some examples of activities that are reasonable. So I've just, a couple of these are, I thought I'd share those with you today. And that's the first one, that you've taken reasonable steps to work out correct pay rates and entitlements, such as checking the relevant award or an enterprise agreement if there is one in place for you as an employer, or confirming that the national minimum wage order applies. Another way that you can showcase that you are attempting to meet the code is that you've sought information or advice from a reliable source about paying employee entitlements correctly. So an example of that is actually calling NatRoad to confirm some pay rates and entitlements. So when you give us a call, we'll ask you a range of questions so we can provide you as accurate advice as we can based on the information that you're providing. A third example is if a quarterly business audit has been done and it's found that a payroll error has occurred and that's been identified. So if you are able to fix that up, then the FO is seeing that as not intentional in their mind, but they will also talk through everything with you when if this is a situation that you found to be in. So if the Fair Work Ombudsman decides that a small business employer has satisfactorily met the code, they will provide the employer with written notice of their decision. The Fair Work Ombudsman can then, cannot refer the employer's conduct for possible criminal prosecution. However, they may still consider civil enforcement options if necessary. So an example of this is they still might issue a compliance notice, an enforceable undertaking, or they may go to litigation. So as we previously mentioned, if you are contacted by the Fair Work Ombudsman about an underpayment, our advice is to cooperate with them to resolve the matter. We think this is a really crucial step. But when we look at this as a whole with the new laws that are being introduced, what actions do you need to take? Well, first of all, review your payroll and ensuring that you're paying your employees accurately. So this includes that they are on the correct award, that they're classified appropriately according to that award, and the pay rate is the most current one. Generally, pay rates increase every year from the 1st of July, and NatRoad sends out information about these pay increases as soon as they are released to help you and other employers meet their obligations. If you aren't sure if you are complying, please give us a call as we can assist you in determining what you should be paying. Now, this leads nicely onto the second point that I wanted to make about, some HR topics to look for in 2025. And this is around reviewing your employment contracts, your letters of offer, and your policies. There has been a lot of changes over the last 2 years in relation to both the work health and safety and the industrial relations laws. So our advice here is to have a read of those, review them, and make sure that they're all up to date. So for example, if you've got an employee handbook, go through, is it still current? Are the practices still the same? Does it actually contain the information where the laws have changed? Or if there's been new laws that have been introduced, do you need to update that and then also communicate that to your staff? If you don't have policies or something like an employee handbook, you might actually like to create one as well, because that is a way of showcasing or showing what the pay and entitlements are within your organization and communicating those to your employees. The other thing to think about is regularly run training or toolbox talks to provide information to your staff about the awards, the pay and condition, just so people know what is going on in the organization. It's great practice to do that on a regular basis. The third topic that I wanted to talk through was termination of employment. And this is probably one of the most common questions that we get. And it is, sometimes they can be really challenging questions because every situation is different. And there's so many different scenarios that can occur in ending an employee's employment. It could be the employee is ending it, or potentially the employer is ending the employment. So some of the questions that come through, the more general questions that come through, are around essentially notice of termination. So firstly, can you pay notice out in lieu? Yes, you can pay notice out in lieu. So this is where you pay the employee instead of them working out their notice period. So that's one thing that you can do. The second thing, a second question that I'm often asked is, can you recover monies if notice is not provided? Essentially, you can recover up to 1 week. However, it must come from outstanding wages and not accrued leave entitlements. So if you've already done final monies and you're just paying out annual leave, for example, you can't withhold the annual leave to be able to recoup any notice of termination or long service leave either. But if you as an employer have agreed to a shorter notice period, then you also can't recover monies. So as an example, if you've agreed to 2 weeks instead of 4 weeks, then you can't go and recover the additional 2 weeks to cover up, to make up the 4-week period. So where do you find out how much information, how much notice must be given? Generally, these are all within the awards. So with the transport awards, for example, not more than 1 year. If an employee has been working less than 1 year, they have to provide 1 week's notice. For more than 1 year, but not more than 3 years, it's 2 weeks. For more than 3 years, but not more than 5 years, it's 3 weeks. For more than 5 years, it is 4 weeks. So the notice of termination required to give by an employee is the same as that required of an employer, except the employee doesn't have to give additional notice based on the age of the employee. And what this means is if an employer is ending the employment of an employee who is over the ages of 45 years old and has worked for you or for the organization for at least 2 years, they are entitled to an additional 1 week's notice. The other question that I often get is, do you have to pay out notice if an employee is on probation? Yes, you do. If an employee's employment is ended while they're on probation, you still have to pay the notice in the employment contract or the employment arrangement. And this is generally based on the award or an enterprise agreement if the enterprise agreement is different, whichever is the greater essentially. Typically for someone who's on probation, it's generally 1 week's notice. The other question is serious misconduct. Do you have to pay out notice of termination if an employee is being dismissed on the grounds of serious misconduct? No, you don't need to provide any notice or payment in lieu of notice, as their employment ends at the time of the decision to terminate their employment and when that's communicated to them. So in relation to final monies, with the final monies, that's another common question that comes through to us. What needs to be paid out with final monies? Essentially, it's any outstanding wages, any leave accrued, so that's annual leave and long service leave. The main question that I do get is, does personal leave or sick leave get paid out? And no, it doesn't. It doesn't get paid out in your final monies. And finals monies must be paid within 7 days of the employee finishing up, so their last day. We'll just discuss the termination on the basis of misconduct. In relation to that, documentation is key. Every single situation is different. So in relation to misconduct and whether you consider that it might be a situation, please give us a call, because it does depend. Do you have policies around this? What communication has occurred? What has been documented? So there's a lot of questions that we'll go through to then be able to provide you with some further advice on terminating on the basis of misconduct. The next topic that I wanted to talk through was casual employment. And essentially this is because the Fair Work Act now contains a new definition of casual employment. So essentially this definition changed on the 26th of August, 2024. So if you have employees who started from the 26th of August, 2024 onwards, the new casual employee definition applies. If you have employees who are engaged prior to that 26th of August, 2024, and they're casual employees, then the old definition of casual employee applies, unless they've moved to permanent employment, and obviously the conditions of employment have changed in general for them. So what's the change? So a person from the casual definition A person is a casual employee if, when they start employment, the employment relationship has no firm advance commitment to ongoing work, taking into account a number of factors, and they're entitled to a casual loading or specific casual pay rate under an award, registered agreement, or employment contract. Whether there is a firm advance commitment needs to be assessed on the real substance, practical reality, or true nature of the employment relationship. And there are several other factors, including whether the employer can offer or not offer work to the employee and whether this is happening. The employee can accept or reject work and whether this is happening. It's reasonably likely there will be future work available of the kind the employee usually performs in the employer's business based on the nature of the business. There are full-time or part-time employees performing the same kind of work in the employee's business as the work the employee usually performs, and the employer has a regular pattern of work, even if changes over time due to, for example, reasonable absences because of illness, injury, or other leave. So that's the new definition of casual employment. It is a little bit different to the previous casual definition. And that definition was where a person is a casual employee if they were offered a job, the offer didn't include a firm advance commitment that the work would continue indefinitely with an agreed pattern of work, and they accepted the job knowing that there was no firm advance commitment when they became an employee. So an example here is if the employee was employed as a casual, their roster changed each week to suit their employer's needs, and they could refuse or swap shifts. That could mean they were casual. So there are 4 factors that determined whether an employer's offer didn't include a firm advancement. So this is just to remind, this is with the old casual definition. So these factors were whether the employer could choose to offer the employee work, and it would be the employee's choice to work or not, whether the employee would be offered work when the business needed them to work, if the employer was described as a casual, and if the employee would be paid a casual loading. So that's where the higher rate of pay for being a casual employee is applied, or there's a specific rate of pay for casual employees. So there is a slight difference between the new definition and the old definition. So what do we need to do in this case? Essentially, it's about reviewing your employee arrangements and ensuring that your casual employees actually fit the definition of a casual employee. If they don't, or you're not sure what to do, please give us a call and we'll work through the scenario with you, because again, every situation is a little bit different, and the relationship between you and that employee, they're all very different. So let's have a conversation and we can help you out further with determining whether your employees meet the definition of a casual employee or whether you need to potentially revert them to part-time or full-time. The fourth HR topic that I wanted to talk through was psychosocial hazards, and this is in the work health and safety space. The Work Health and Safety Act across the country, they are amended to include a specific duty around managing the risks of psychosocial hazards. So work health and safety regulators have developed codes of practice to assist you in meeting this duty. So you can get all of those on their websites, but what we'll do is also include some links on our members portal so that you can access them really easily. So why is it important to manage psychosocial risks? Well, psychosocial risks is if you've got them in the workplace, psychosocial harm or injuries from psychosocial hazards include conditions such as anxiety, depression, post-traumatic stress disorder, and sleep disorders. You can also get physical injuries from psychosocial hazards, including musculoskeletal injury, chronic disease, and physical injury following fatigue-related workplace incidents. So they're really, really important risks, the same as physical risks. So it's really important to manage both your psychosocial risks and your physical risks while you're in the workplace. So some of the hazards that might arise at work. So it could be around job demands, low job control, poor support, lack of role clarity, poor organisational change management, remote or isolated work, bullying, violence and aggression, harassment, or conflict and poor relationships at work. So if any of those hazards are in your workplace, it's about doing a risk assessment on those and determining what are the most appropriate controls that could be put in place to manage the risks. As I mentioned, the codes of practice that have been developed do take you through how you can manage psychosocial risks and psychosocial hazards. So what we'll do is pop a link onto our website about that, so you can have a read of those and do a risk assessment within your business so you can manage these risks into the future, so far as reasonably practicable. Now, the final piece of HR topic or advice that I wanted to talk through today was just some common questions that I've seen from members more currently over the last couple of months. And there were two specifically that kept coming up. And one is around annual leave loading and whether that's payable on termination. And the other is about loading and unloading payable under the Road Transport Long Distance Operations Award. So these have been really common questions that have come through, which the awards can be quite clear on one of the awards, but one of the awards is also a little bit grey on it. So with the Road Transport and Distribution Award in 2020, yes, annual leave loading is payable on termination, and the rate is 17.5%. So you pay their base rate of pay plus the 17.5%. With regards to the Road Transport Long Distance Operations Award 2020, annual leave loading is payable on termination and the rate is 30%. So it's a different rate to your Road Transport and Distribution Award. There is a little bit of confusion that's come up with this award because there's a clause in that award that appears to indicate that leave loading doesn't need to be paid. However, the National Employment Standards in the Fair Work Act actually overrides this clause. So it's section 90, subsection 2 of the Fair Work Act states that employees will be paid annual leave on termination at the same amount payable to the employee had the employee taken the period of leave. Now, given this clause in the Act and the National Employment Standards apply, this sort of means that under that award, under the long distance award, annual leave loading is payable on termination. The second question that has been that I've been asked a little bit over the last few months is around loading and unloading and how it's payable under the Road Transport Long Distance Operations Award. And this is in relation to clause 16.6 of the award. And this is something that I've been talking with the Fair Work Ombudsman about, just to try and find out what their sort of view is and how they would interpret this. But I've also been talking to various members because there's lots of different scenarios that can happen in this instance. So what I would like to do is welcome you to give us a call and talk through your scenarios with us, because the information that I'll give today might not fit your exact scenario. So please give us a call so we can have a conversation about your specific scenario, because it might be that a different interpretation might need to apply in your case, or this particular interpretation is correct. So when I last consulted with the FO, the understanding of the meaning of per trip under clause 16.6 is for the entire round journey. So that's what we're looking at. So an example is if the employee loaded in Melbourne for 30 minutes, then they loaded in Canberra for 30 minutes, and then they unloaded in Sydney for 30 minutes, the total payment for loading and unloading would be 2 hours. And this is because there's a minimum payment of 1 hour for loading activities performed within the trip, and there's a minimum of payments of 1 hour applies to the unloading activities performed within the trip. So all up, it's 2 hours, even though they only did an hour and a half. It's about what the award's indicating is the minimum that an employee must be paid for both the unloading component and the loading component. But as I said, I do understand that there are different scenarios of unloading and loading out in the industry. So I really welcome anyone to give me a call, and we can have this conversation further about your specific situation. And that's the last topic that I wanted to talk through today. Um, If you have any questions regarding managing your employees, please contact us. We really look forward to hearing from you, and we welcome any questions. And all of these questions actually help us to develop more of these webinars so we can inform you about what's happening in the industry, and also just give you any tips or advice that we've found out along the way. So please give us a call, and I look forward to hearing from you. Thank you very much.
Thank you, Kylie. Appreciate your time. We'll talk again soon.